welcome to another edition of Reasonable Doubt, the show brought to you by the Harris County Criminal Lawyers Association. I'm your host, Jimmy Ardwan. Tonight, my co-host filling in, JoAnne Musick, stepping in for Julio this evening.
Hello, how are you?
I'm good. Glad you could be with us.
Thank you. Glad to be here.
We seem to have our music running over a little bit, but that's okay. Our guest this evening, Dane Johnson, lawyer extraordinaire. How are you, Dane?
I'm well. Thanks for having me.
I'm glad to have you on. We've been trying to get you on for a while. Good we can get you on finally this evening. We got a lot of stuff to get to tonight, ladies and gentlemen. A lot of big stories happening both here in Houston and nationwide that we're going to talk about tonight. We got Twitter up. We'll take your questions and comments at HCCLA_TV. Send us to them right here on the air. For me, JoAnne, or Dane, we'll answer your questions right here. We'll also open up our phone lines starting at 8:30. 713-807-1794 is the number. We'll flash it at the bottom of the screen. Also around 8:30, we'll take our break to do a 60-second law lesson for y'all. Guys, I want to get right into it tonight. The big story, obviously, sensationalized throughout the media, is the suspension of the Harris County Sheriff's Office investigator, Craig Clopton, with regard to the Deputy Goforth murder. This is just a bizarre case. I mean, it really is. Apparently, the investigator Clopton, has admitted to having a consensual sexual relationship with a key witness in this case, the same one who was alleged to have an affair with Deputy Goforth, and was at the scene. I mean, this is pretty bad, isn't it?
It's incredibly bizarre. It is strange. It reads like this ought to be a bad TV movie. You've got the deputy who's gunned down, and then you have a witness who's there at the scene who isn't disclosed. That witness happens to be having an affair with the murdered deputy. And then we find out.
Isn't there some suggestion, JoAnne, and pardon me for stepping in, but that witness that you're talking about, I understand there was apparently two witnesses. This woman was apparently taken from the scene, yes, unbeknownst to a lot of people, and that has now started to trickle through.
Right.
She was kind of secretly taken by the deputies.
Yeah, something going on here. She's present, and witnesses say, there was a lady here. She was bent over talking, and then all of a sudden she just disappeared. And we have deputies allegedly escorting her out of the scene and neglecting to mention her in their offense reports. Then we find out that's probably because she was having an affair with Deputy Goforth. Then we find out, she's having an affair with the investigator that's heading up the homicide investigation.
I guess, guys, why in the hell was Harris County Sheriff's Office investigating this case in the first place? Why were they not taken off?
Great question you have there, and something that we've all asked ourselves. It should be an independent investigation. When one of your own is killed, you've got to get an outside source in, whether it's the Texas Rangers, whether it's HPD, or an outside source, DPS. Let somebody else take over that investigation. You're just too close to the situation. This is one of your own brothers that have fallen, and you've got to bring in somebody from the outside. And what's really strange and bizarre, what JoAnne's talking about, is how did all this get covered up?
Yeah.
How did it get covered up for so long, and we're just now getting the pieces of the puzzle? What other pieces are missing? What other things are we not being told? We don't like to try things in the media on the defense side, but we should not be kept from the truth.
Well, and the crazy thing, guys, as you both know, you watched the press conference right after this happened, and I mean, Sheriff Hickman is out there talking about all lives matter, trying to really, as we talked about on the show, right when this happened, the week that happened, we talked about on the show how we felt that the press conference itself was drawing even a bigger divide based on the tone and tenor of it in the racial divide that's going on right now in Houston between cops and minorities. And it was, this war of cops' lives matter too versus versus Black Lives Matter versus all lives matter.
Absolutely.
And so now we've got this coming out. It apparently looks as this is not a case of what they wanted to make it out to be, which is some body who's trying to prove a point with all these hashtags going around murdering cops, but instead is mental illness at a minimum, and maybe something even more crazy going on.
Right, yeah, and it brings it, I'm not even remotely suggesting this as a reality, but this type of investigation that's biased, that's clouded, that's interwoven with the investigators of investigating their own agency, investigators having affairs with the witnesses they're investigating. You know, all of that's being hidden as if there's some bigger secret agenda out there. You know, are they trying to protect her because she's a suspect in something? I mean, I don't think she is, and I don't think anybody's suggesting that. But what are they hiding? There's no reason to hide that.
The truth will set you free. It's oftentimes the cover-up that's bigger than the rest of it. And there may not be a cover-up at all, but it just doesn't pass the smell test. We're talking about an investigation into the Harris County Sheriff's Department, by the Harris County Sheriff's Department, and now we're finding out that there's a cover-up, there's sexual scandals, what's getting lost in all this, and what has been lost, is it's turned into a sensational thing. That poor woman, Goforth's wife, who's having to deal with this on the back end.
Exactly.
That's being lost in the story at this point. Who knows what the connection is? Maybe it is a mental illness issue. Maybe there was something going on with the person. This needs to be disclosed to defense. And I know that the lawyer that's handling the case has taken some criticism in this case.
He has.
For suggesting that he may or may not have been in the line of duty. But we as lawyers have an obligation to investigate these things. And unfortunately for us, we're dependent on the investigations oftentimes that the police have done.
Right.
They have access to a lot more information than we do. They're the ones that are out at the scene at the beginning of the investigation. They're the ones that control the evidence from the outset. And when you manipulate that from the outset, it calls into question everything else that's been done in the investigation.
Well, it calls the whole department into question.
Yeah, this
from
whole
Hickman all the way down.
Right. This, and I'm really troubled by the fact that they took this woman like right away.
Yeah, we needed to hide her.
We needed to hide her.
We needed to hide her and hide what's going on. That's not an open, independent, fair investigation.
No. It's almost like they knew ahead of time that he was, I mean, I don't want to get into speculating on the facts, I mean, but it just, it's reeks.
It does. It reeks. You know, and sadly what happens tragically is Goforth's wife and family are being drugged through this. Clopton's wife and family and kids are being drugged through this. The whole department's being drugged through this when it didn't have to happen. It didn't have to be that way.
I mean, at this point, what good? I mean, obviously, somebody else has got to step in and take over the investigation from this point forward. And I don't know who it's going to be. I can't imagine that the sheriff's office is going to continue to investigate this case. I think the DA's office. We haven't heard
anything about them saying they were going to step aside, though, or calling for an independent investigation.
Yeah, but I mean,
Hickman could step up and say, you know what, Texas Rangers, come in and help us.
Yeah.
But he hasn't.
But even if he does, is it really? I mean, at this point, the investigation seems so botched. I mean, what is there to salvage at this point for law enforcement? And
what other investigation needs to be done at this point?
Yeah.
What leads have not been followed? What loose ends are out there that they didn't follow up, or that they covered up, intentionally covered up?
Or that they ignored.
Or that they just ignored. I mean, was there some connection with this woman and the killer? We don't know that.
Yeah.
Well, she's connected to at least 2 deputies that are there. So how many people is she connected to? I don't think we'll ever know.
Have y'all ever seen anything like this?
I've never seen this. I've been in Houston my entire life. I've handled hundreds and thousands of cases, both as a prosecutor and a defense attorney. I've never seen this.
I mean, I just can't think of a case that has had this much problems with it from.
But I guess we could go back to Temple and talk about all those problems.
But I mean,
those were created in the courtroom, not at the scene.
Yeah, I mean, this is from the very get-go. So many problems, so many questions. I mean, this is just bizarre. We're going to have to, this is going to be an interesting case to watch because it's going to take time. I'm guessing, what do you guys predict, a year or so before this thing goes to trial?
At least a year, maybe longer. Especially if there's mental health and psychological issues, we could end up seeing the suspect, the defendant, sent off to psychiatric hospital to delay things while he gets treatment. So easily a year to a year and a half.
Well, we'll watch it. We'll obviously keep you guys informed of what's going on. Next story I want to turn to, guys, is we had a little bit of a head start on it in the defense bar because we knew about the memo, and it's the issue of now there's this suggestion that some of these DNA profiles and the DNA labs, they may have some problems. That these results may not be what all they're cracked up to be. And, you know, NPR has caught the Texas story that has been going around circling amongst at our level, at the attorney level, and NPR finally picked it up. The Houston Press picked it up. So we've got some major outlets now running with it. But it's a problem. I mean, they have now gone back and said that the DNA, and you wrote a blog article about it, JoAnne. So I think I should turn to you because you've done the most research and the legwork on this.
Well, I have. I've followed this from the beginning. I've written 2 or 3 blogs on it, both on the HCCLA.org and HCCLATV.com. So there's a couple blog posts out there with some research. But basically what we have is 15 years ago, everybody said DNA is the new sliced bread. It's great, it's perfect, it's better than fingerprints, it's better than anything, and we can tell you who left this sample at any particular crime scene. And now it kind of turns out that's not really quite the case. We used to get these results that said DNA, this is Jimmy's DNA, and we are certain to within 1 in a billion people. So it would take, a billion profiles before we would see this again. Now we're seeing those numbers at 1 in 10, 1 in 3, 1 in 400, much, much lower numbers. And it has to do with an error that was in the FBI database that was used nationwide by all crime labs starting in 1999. And the problem has perpetuated since 1999.
That's crazy. I mean, I don't know how you could go from 1 in a billion to now some saying it's 1 in 3. That's a dramatic.
Huge.
It's a huge difference. It's actually really troubling as a lawyer, and it kind of undermines our entire faith in scientific evidence. I mean, not just DNA evidence, but whether it be blood analysis, whether it be DNA, whether it be fingerprints. There was an individual in Smith County many years ago that was convicted, Carrie Max Cook, of capital murder and sentenced to death row. Spent 25 years on death row with junk science, and it turns out that this is turning into that. He was convicted by a individual saying that a fingerprint, they could tell how long a fingerprint had been on a window. And that was the critical piece of evidence in that case. Now, obviously, that we all know that you can't do that, but they convicted him on that. To me, when you start talking about science and you start undermining it, we're talking at a national level. We're not talking at some little local lab here in Houston or some local lab in Pasadena or some small community. We're talking about the FBI database.
Right.
And we have all, and ourselves included in this, defense lawyers, relied on those databases. And now we're finding out they're not true. What else are there? What else did they get wrong? What else can we as lawyers, what else do we need to question?
Well, this is the second because the bite marks, that was the last one.
Right, as I say, we saw bite marks, we saw dog sniff analysis, we see piece of science after piece of science that's being used in criminal cases being undermined and turning into what we'd call junk science. Everybody has this opinion. We can tell if you're intoxicated by the little finger nose test. Well, no, that doesn't really work. We now need to do an HGN. Well, no, that's not quite all that accurate. So now we need to do, it's every piece of science that they're using to convict people in crimes across the country that we're turning out to find probably is not quite as reliable as it once was thought to be.
Well, and doesn't it just call into question our entire system? I mean,
Absolutely.
really, I mean, and forget us as lawyers who, this is what we've chosen to do and we enjoy what we do. But as a citizen, aren't you offended that they have been convicting citizen after citizen after citizen for the last 15, 16 years on science that just simply isn't accurate?
Exactly, and that's part of the problem. Now we have to go back because Chapter 64 in the code here in Texas gives you a right to challenge that DNA post-conviction. So we're now looking at people that were convicted in 99, 2000, all the way up through now, have already been in prison, may be out, done their time. They can go back and have that retested now.
Yeah, but I think it's, what you said about how people should be really questioning this. You look at all the law TV shows out there.
Watch CSI.
Law and Order, all these things. And we've often joked about that juries see that and they believe that to be the way things work. Oh, that's the way law is practiced. That's the way things go in the courtroom. And we always joke and say that's not how it goes in the courtroom. But I think the more troubling aspect of that is they believe, and I think that the judges and the prosecutors have also started to believe, that this technology that you see on the courtroom that is on the TV is infallible, and that's exactly what we have over in the FBI or at this lab. And it's not. It's just not. I mean, they're making stuff up. Is essentially what it sounds like.
They're making stuff up and they're guessing.
Yeah.
We've trained this dog to alert on narcotics. And so when he sniffs some money and smells narcotics, it must mean you're a drug dealer. We all know, after years and years of tests, that almost every piece of U.S. currency will have some trace of drugs on it.
Well, and it sure sounds better to say it's a 1 in 1 billion chance of this person rather than a 1 in 3. I mean, because if you're sitting there on a jury, you go, 1 in 3. Well,
4 of us on the jury could be the suspect.
Exactly.
Versus 1 in a billion.
Versus 1 in a
there's
billion.
3 people in the entire world. What's there? 6 people in the entire world. What's the odds of that? It's troubling, to say the least.
I mean, is it science manipulation? Is it statistical manipulation, JoAnne? What have you found and what you've researched?
I think it's a little of both. It is a statistical problem that started, but then technology has advanced, and we're now seeing that we can pull different levels of DNA out of samples. And so not only did they change the statistics now, starting in 2015, but they've changed the, if you want to call it, the upper and lower limits. You know, we everything that we do in science, we say, you know, well, the breath test in a DWI case is a 0.08 plus or minus a 0.02, because we got a little room for error in there. Well, we had that room for error in DNA analysis also, but now they've shifted those floors and ceilings to include more people and exclude more people. So we have cases coming up now that said this was a match, and now we're saying under the new technology, new science, that, you know what, we really can't say if it's a match or not. So we can't even get to the statistical number because we don't know if it's a good enough match.
We've got a good question coming in on Twitter on this issue, guys, and it says, where does one start to investigate to see if their case has one of these issues? And I think that's a great question.
It is a great question. The first thing you want to know is if we're talking post-conviction or current case.
Yeah.
Post-conviction, you've got to go back and know what evidence was used in your case. If you are the person that was accused, obviously you will have some idea. We as lawyers have to know too, and we have to sit back and think, well, gosh, back in 2004, I defended somebody and DNA was an issue. I need to go back and look at that and say, was DNA the only issue in the case? Or was there also an eyewitness identification? Was there also video? You know, DNA might clear you, but if there's video of you at the crime scene, doesn't really matter what the DNA shows.
Right.
So make no mistake, this new DNA statistical calculation is not going to clear everybody, but it's something to look at. Was everybody relying on it being a match when it really wasn't, and that led to somebody taking a guilty plea?
And that, I think, is the crux of the problem. How many people have said, look, I can't beat the DNA evidence. I know I'm not guilty,
right.
but I mean,
but
they're saying it's 1 in 10 billion people. I'm the only person on the earth that has this DNA.
And a jury's never going to believe me.
And you're facing
so I need to go ahead and
I can't afford an expert to come in and challenge this, and somebody who actually knows their stuff to come in and rebut this.
And the sad part about that is even an expert may not have helped you back in the day.
Right.
Because they were dependent on these same databases.
I was going to say, they would have used the exact same
was
statistical numbers, so they would have came to the same opinion.
You know, when you're talking about it, JoAnne, but how does somebody, and to kind of piggyback on our viewer's question, if you've got a case that's 20 years old, for instance, and you were using this rinky-dink science, and it was probably even worse back then than it has been, let's say, even in the last 5 years or so, how do you even go about reopening something that's 20, 25 years old if you believe you either pled guilty or convicted based on flawed science?
It's a writ of habeas corpus. That's the only avenue left in these cases. So you might have a Chapter 64 proceeding where you're going to look at the DNA, or it might just be a typical writ of habeas corpus. Writ of habeas corpus means I'm being detained illegally and I want it reinvestigated. So we file, in legal terms, what we call a writ of habeas corpus. That gets us back in front of the court to introduce additional evidence.
Realistically, though, I mean, what's the chances of someone being able to be meritorious in that? I mean, how do they go about getting...
Statistically, and I hate to use statistics because we know they're bad, but
they're flawed.
Statistically, your chance of winning on a habeas claim are probably less than 1%.
Yeah.
So it's extremely difficult, and it's going to take a lot of time. And just kind of piggyback on that, we know DPS has already identified 2,000 and some odd local cases here in Houston that need to be relooked at.
Well, and that's just in Houston.
Right. And that's just from the DPS lab.
Yeah.
That doesn't include the Pasadena lab or the Harris County lab or any other labs that we use locally.
Gosh, it seems like such a uphill battle I mean, we know it every day, but when you start putting it in perspective on these statistics, like you were saying, a less than 1% chance of getting the writ granted, then you see the statistical manipulation, which, as you pointed out, Dane, can make a defendant go, well, how the hell am I going to beat that? I mean, you really start to look at this and you're like, the deck is so stacked. The government really has the power to manipulate the evidence in such a way that it just comes down on the citizens. What do we need to do to step up with this, Dane?
I think that it starts with honesty and integrity in science, and that's where it really starts. And I will, in fairness, give them some credit for coming out and saying that the statistics have been wrong. We've been doing it wrong. So there is some, if you want to say, silver lining in this. However, it starts also with us as lawyers. We as lawyers have to be more critical and more educated in our analysis. We need to bolster our skills when we're dealing with a DNA case. I've never dealt with a DNA case. I'm not competent to handle a DNA case. It's not my wheelhouse. I do what I do very well, but it's not in my wheelhouse. It's interesting to me that lawyers that are general practitioners, I have no idea how they do it. Because at the end of the day, I do DWI work primarily, and I know it very well, but you get me outside of that realm, even in the criminal field. And so these folks that handle DNA cases, and it sounds like, JoAnne, you handle a lot more than I do, or more than me, because I don't handle.
Yeah, some.
Science is very difficult to deal with as a lawyer because we're not trained as scientists. We've got to get experts involved. We've got to educate ourselves. We hope, and I think we may touch on this a little later talking about prosecutors, we hope that prosecutors are doing the right thing and giving the evidence to us because we are dependent on them. I mean, what do we do to get evidence? We go to the prosecutor and say, hey, what's in your file?
Right.
Then we may hire an investigator based on that evidence, but we are dependent on them. If they don't put a witness in the report, it is very difficult 6 months later for us to go back and try to find a witness. And so we are dependent on these investigators that we just touched on, these very shoddy investigations that are done. And we're dependent on the prosecutors actually handing over all the evidence that they have.
Well, and you talk about, we as lawyers need to get better skilled and rely on experts. I think it goes further than just us. The judges need to start being a little more critical of what evidence they allow in as the gatekeeper. The prosecutor needs to be a little bit more critical. Just because a lab brings you something doesn't mean it's true. Just because a police officer brings you something doesn't make it true. As a prosecutor, you've got to question that. You build your case from there. As a defense attorney, we've got to question it. And the judges have got to start following the law, having these expert hearings outside the presence of the jury, and being a true gatekeeper.
And that's one of the things that I think we are all frustrated with as lawyers is we don't feel like there's a gatekeeping function being
Not in Harris County.
Administered in many of the courts that we're in. It's the government offers it, it comes in. It doesn't matter what credentials somebody has. They said the magic words, and therefore it comes in.
We talked last week, guys, about the indigency problem in Harris County, and the topic last week was how the system works for everybody but the indigent.
But the poor, yeah.
And this seems to me to be the top of the pyramid, if you will, to illustrate the problem of the indigent defense, because where's the money for indigent defense in a DNA case?
Well,
where is it?
Yeah, it lies with the local taxing authority, which is Commissioner's Court here in Harris County, but you've got to go to the judge. We've got to know as defense lawyers we need it. And then we've got to go to the judge and get permission to spend it. And then it's got to go to, through all the rest of the channels and make sure there's enough budget there. This could be a huge undertaking that could end up costing the taxpayer hundreds of thousands of dollars. But that's why we should be a little more critical. Whether you're the prosecutor, the judge, whomever, let's be critical from the front end and save all that time and money.
Well, and that's what I was going to ask too, and I don't know the answer to this question. That's why I asked the question. What are they doing about the cases that have been going on for 15 years? Are they going back to go back and retest? Are they going to, what's the remedy for somebody if somebody does want to go back and have their case reopened? I understand it's a writ, but does the government bear some responsibility in going back and doing the testing of the DNA?
To be fair, I will say the prosecutor's offices locally, that includes Fort Bend, Harris County, Galveston, the prosecutor's offices that I know of are stepping up and trying to do the right thing. They're using their integrity units and post-conviction units to go back and find cases that need to be re-examined. We also have the labs looking. Like I said, DPS has identified 2,000 cases that they want retested. So they'll provide that 2,000 to the prosecutor, and the prosecutor will expand on that list and take a look at each one of those cases and say, how big a role did DNA play in this case? Do we need to reopen it? Was it important? Plus, they're notifying defense counsel.
But isn't that, I mean, realistically, guys, isn't that a little bit like the wolf watching the hen house?
It's always that way, yes.
Yeah, but I mean, seriously, I mean, at some point, don't we have to find a better solution in not having the DA's office to go in and reevaluate these cases? Because to me, there doesn't seem to be an incentive for them to come out and, en masse, overturn a bunch of these cases.
I guess it goes back to our original topic here. And why is the Harris County Sheriff's Office investigating a Harris County Sheriff's deputy being killed? Why is the DA's office investigating an error that the DA's office created? I think it's a huge problem. Why not get an outside source? I think it's a valid point. Unfortunately, that's not going to happen, number one. But do they have the resources to do it? Does another outside firm? Give the cases to somebody on the outside. Let you evaluate it.
Or better yet, I mean, you've got all of these big white shoe ivory tower firms filled with all these brilliant Harvard-educated lawyers who do a lot of pro bono. And I'm sure if you set up some sort of fund within the state to go in and evaluate this, let them do it. They're smart, they're independent, they have no skin in the game. Why not have somebody like that? You know, get a Baker Botts or somebody, or what used to be Fulbright and Jaworski, now the conglomerate that it is. But why not somebody like that?
Well, it makes perfect sense. It's just probably not that realistic. They do pro bono work where they can. I think they probably ought to do a little more considering the amounts of money that they make. But be that as it may, you know, the state's not going to be able to fund Baker Botts rates to do this.
And I'm not suggesting that they should, but at some point, like you were saying, Dane, as lawyers, we owe it to the system. I mean, whether you are a civil transactional lawyer, a civil litigator, a criminal lawyer, a writ lawyer, an appellate lawyer, whatever your specialty is, isn't there a duty amongst all of us in the bar, no matter what your profession is, to try and do better for society? And isn't this a society thing that we should all strive to help out, no matter whether it's lining our pockets or not?
You're absolutely right. It is a societal problem, and we talk about it from a courthouse perspective and from the judges, prosecutors, defense attorneys. But it is a bigger problem. We need the voters, we need the public to care about it. And unfortunately, what ends up happening is they don't really care till they end up in the system somehow, or a friend or loved one ends up in the system. Then their eyes are opened, and all of a sudden they're saying, wow, why is all this happening? We need them to wake up before it gets there.
It's a true integrity problem. I mean, that at the heart of the matter, I think what you're getting at is the system doesn't work if you have faulty science being the basis of that system. And if we don't have integrity in the system, if we can't trust what these scientists are saying, we can't trust what's going on out there in the scientific community, it undermines the entire integrity of the system. And I think this has far-reaching potential implications for not only DNA evidence, but I think this may be the tip of the iceberg where people do start questioning and start saying, wait a minute, we've been convicting people for years because the gold standard has been DNA. Now we're learning that maybe that's not the gold standard. Maybe that's the silver standard. Maybe it's the bronze standard. Maybe it's not a standard at all. And we may have to reevaluate all the scientific evidence. I'm hoping, like what JoAnne said, is the judges start using this as a gatekeeping function for all scientific evidence. Let's look at the real scientific evidence behind, or the scientific data behind, the evidence that these people are trying to bring to the table, and make sure it does pass the qualifications.
You would sure hope. I mean, it's a problem. It's sad to see, but hopefully we find some sort of solution to make it better for all of us. We've reached 8:30 now, and we're going to open up our phone line. 713-807-1794 is the number. Again, we've got our Twitter feed up and running here at HCCLA_TV. But right now, we're going to present our 60-second law lesson brought to you by the Harris County Criminal Lawyers Association. This week, our lesson is brought to you by Jen Gott, and she'll be talking about asset forfeiture.
I'm attorney Jen Gott, and I'm here to talk to you about asset forfeiture. What is asset forfeiture? It's the law that allows police officers to seize your personal property, your cars, your cash, your jewelry, whatever they want if they think it is somehow connected to a crime. Once they seize your property, the district attorney's office has 30 days to file a petition against your property in civil district court. After they file that petition, you should receive a copy either by certified mail or a process server will hand deliver it to you. When you get that petition in your hand, you need to make sure that you contact an attorney and file a response to that petition in civil district court within 3 weeks. If you don't timely file an answer, the district attorney's office will get a default judgment against your property. What does that mean? That means they get to keep your property. So if you find yourself in a situation where law enforcement has seized your property for the purpose of asset forfeiture, make sure you consult an attorney, be on the lookout for your petition, and number 3, timely file a response. I'm attorney Jen Gott, and this has been your 60-second law lesson on asset forfeiture.
Thanks, Jen. Great advice for everybody. If you know somebody who could use Jen's advice or any of our other 60-second law lessons that we've given, head over to our website, HCCLATV.com. We'll have all the law lessons up there tomorrow. We'll also post them to our Facebook page tomorrow afternoon. You can go like us on Facebook and follow all of us over there. You can send us topics and guests that you'd like to see. Just about anything. We'll post all of our topics in advance, and you can comment. We'd love to get your questions in advance before we hit the show. A reminder, we got the phones open, 713-807-1794 is the number, so call in for questions for me, JoAnne, and Dane right here live on the air. Guys, I want to go to the Harris County First Chance program because that's getting a lot of attention here the last couple weeks. You know, they introduced this program last year. The First Chance program, of course, was supposed to be a diversion program for first-time offenders of possession of marijuana with personal use amounts, small amounts, under 2 ounces. And the statistics don't bear out, at least in my belief, that the program is really doing what it sought out to do. Some of the statistics are a little crazy here in the sense that we've got, the success rate has been very, very good, I think, in that 81.5% of the participants have successfully completed the program. The big problem I see is that this program was sold to everybody as a way to avoid actually going to jail and actually having to come to court in order to do this. And the statistics seem to show that that's only happened for about 19% of the people. I don't think that's a success.
Colossal failure. I mean, look, I mean, a 19% success rate of not going to jail. I mean, if the true intent of the program, and that's the way it was billed, it was sold, as this is a diversionary program to avoid going to jail and avoid a conviction. 19%? I'm no numbers guy. We were talking about statistics earlier, but 19% is not doing the job. Look, it starts, I think, and I don't know where the breakdown in communication is. I don't know if it's in the DA's office. I don't know if it's the police officers don't know about the program. They're not taking advantage of the program, or they don't want to take advantage of it. I don't know, but 19% is just not getting the job done. I mean, why even have the program? Well, you can do it on the back end of it if you're only going to have 19% avoid jail. What's the point?
Yeah.
Well, Dane, you bring up a good point when you say you don't know where the problem lies. Is it the police officers don't know about it? Is it the citizens don't know about it? Where's the problem? And the problem starts, it was a great program, and I applaud Devin Anderson for setting that up. The problem is she does not require officers to use it. So then you step down from that and you look at, well, what officers or what agencies are even able to use it? Right now, I believe it's only the Sheriff's Department and the police and the Houston Police Department, not the constables' offices. So anyone in a constable's office, out in Jersey Village PD, in a school PD, any other zone is going to end up in the old system where they're arrested, booked, and taken to jail, and then end up in court. The officers themselves, what I'm hearing, and I heard in a Harris County Criminal Justice Coordinating Council meeting a little over a month ago was that HPD reported their officers don't really like to use the program. And it's sort of a two-step process for them. One, they're not allowed to use the program in their outlying areas. They have to take the person who's going to be offered the program all the way downtown instead of using their smaller substations around the town. So now you have an officer who's going to go out of his way, go downtown. This is a longer time he's off the street. It's a longer time he's not making reports. It's a longer time he's not making calls. And it's a longer time he's not making arrests. Officers, whether we want to admit it or not, work on quotas. They're not hard, fast, written quotas, but if they look unproductive because they're not making arrests, that's bad. So they don't want to be in that position of looking like they're not making arrests. They want to make the arrest and send them to court. Let the court sort it out.
Yeah, we've got a call coming in on this very topic, so I want to jump over to the line. Hello, welcome to Reasonable Doubt. Thanks for calling.
Yeah, hi Jimmy. Good show tonight.
Thanks.
You know, this is a great topic here, and according to HCCLA policy guidelines, it seems like on-site supervisors can choose to deny the program to the eligible officers anyway, or the offenders, when deemed appropriate. So, in other words, what is that saying? An officer doesn't want to, or they don't have to? It basically gives them full discretion, you know, to go ahead and charge somebody if they want to or not. So, you know, what's the point of this thing? They say it's only 60% effective in the first place. And, I mean, do you think they're going to throw this thing out, or are they going to use it, or how long is this going to last?
Great question. Thanks for the call. Yeah, I mean, there is too much discretion, I think, amongst the officers. If you're implementing a policy, as you said, Dane, this is kind of a colossal failure because there seems to be a disconnect between the DA on one hand and her policy and how she's communicating, implementing that policy with law enforcement.
Well, law enforcement's looking at it as an optional program. If you don't make them participate in it and it's only optional, 9 times out of 10, the officer's going to opt out.
Well, isn't there a pretty simple solution to this? And that is, they have direct intake here in Harris County, where you actually, the police officer has to physically pick up the phone, call the district attorney's office, and ask them if they will take charges on something. Isn't it a pretty simple solution to have the DA say, offer them the first chance program. Do not take them to jail. Why are we even talking on the phone about this?
And to the caller's point, what's the solution? And I think what would be a good solution and what you're on the long lines of is you get picked up, do it like a traffic ticket. You know, say, here's your date. You need to come down to the DA's office to sign a bunch of paper. Here you go.
But you know what, Dane, and you hit a really exceptional point there. The DA's office has direct filing and an intake that runs 24/7. So the officer does have to physically call a prosecutor on every single arrest and say, will you accept the charges? You know what? They could say no.
Yeah.
They could say, you know what? Send them to the diversion program, send them to first chance. And then if the officer says, well, I don't really want to do that.
Let them go.
Let them go then. You know, the DA can enforce this by stopping the process at intake.
Right. I mean, they have DAs that are down there, like she said, 24 hours a day, 7 days a week. That's what they're there for, is to talk to police officers and determine whether they're going to accept charges on a case. I mean, that seems just like a no-brainer solution if you want the 19% to go up.
Yeah.
And if you want to just catch them, release, and let them go because you don't want to do the paperwork, that's on you as a police officer. That's on you as a police agency. We're going to tell you the program's available. We would like for you to take advantage of that program. But at the end of the day, if you don't want to do it, let them go. I mean, ultimately, aren't we getting to that at some point anyway?
I think so.
I mean, Colorado's done it. Washington's done it. I was out in California recently. There's a head shop on every corner for medicinal purposes. And there's a litany of purposes that it can be used for. I mean, aren't we a little antiquated here in Texas? I know I'm a criminal defense lawyer, but aren't we a little antiquated here in suggesting that marijuana is illegal for all purposes? I mean, give us 10 years and I think it'll be a moot point, but I mean, hopefully, I don't know.
But in the meantime, the option is stop filing the cases and let these people have a chance at a success, because we're only talking about low-level first offenders without criminal history.
In fact, the lowest levels. The Class B misdemeanor amount. It is the absolute least amount that you can have to be charged with marijuana.
Less you can get.
If you have something more than that, you're not eligible for the program. So those statistics aren't even in here. Those people go to jail 100% of the time. This is for the somebody has a joint, has a whatever in their system. I mean, in their possession. That's it.
Yeah. We got another call coming in. I want to jump on the line and take this call. Hello. Welcome to Reasonable Doubt. Thanks for calling. Hello. Hello. No. Nobody there. I guess. All right. Sometimes that's what happens. They
Maybe
hung
we
up
left
on
them
us.
waiting too long.
713-807-1794 is the number. You can call in with any questions. Guys, switching gears a little bit, California just passed a new law that actually puts some teeth into prosecutorial misconduct. And I think it's an amazing law in the sense that what it does is it actually, if warranted, allows the judges directly to remove prosecutors from a case if they feel it's warranted. And then it also requires the judge to report the offending prosecutors to the state bar.
Brilliant.
Huge.
This is something
Huge
that we've
step.
all talked about for years. Why is there no enforcement of violations of Brady, which is where, for the audience that doesn't know, that's where the government has to give us as defense lawyers anything that may tend to exculpate or mitigate our client's guilt or their punishment in a case. Why would a prosecutor not want to give this over? This is something that's been foreign to me. I mean, we've battled with Michael Morton, and there have been some wonderful lawyers that have battled for Michael Morton Act to give us access to information. I was a prosecutor 15, 18 years ago, whatever it was. I was of the opinion, give them everything. If you've got the goods on them, give it to them. Here's what we have, and this is how we're going to convict you. Give them everything. What's the harm in that? But the problem that we found is not only were they not giving us the information they thought to convict us, they also weren't giving us the information that tended to show that somebody else committed the crime, or that you had a mental illness that we were unaware of, or things that tended to mitigate those circumstances. And I think the law is way behind the time. I'm thankful that they passed it. I hope more states will do it. I hope we do it here because it's necessary in our system. We don't want prosecutors hiding evidence from defendants, period, bottom line. Whether it's good or bad, we just don't want that.
I think we got a call on the line, so I want to jump over. Hello, welcome to Reasonable Doubt. Thanks for your call.
I had a question in reference to cold cases.
Yes.
How do you feel about cold cases with no DNA or video?
With no DNA or no video?
Yeah, how long should they normally last in court?
Well, I mean, every case is different. It's hard to say how long a case should last in court, but my guess is, and y'all feel free to chime in, that if it's a cold case with no DNA and no video, it's probably not likely to get prosecuted.
Well, I kind of think it's just the opposite. Those are likely to be prosecuted.
You do?
That's the new crime du jour. That's why we have cold case TV shows and reality series. They love to prosecute those cold cases. Maybe they're cold for a reason. Maybe witnesses didn't want to participate, and maybe there wasn't enough evidence, but they're being revived nowadays, and that's kind of the crime du jour, is to be able to prosecute those. So I think they're prosecuting them heavily where they can, and obviously it depends case by case what other evidence there is. Are there witnesses? Are there photographs? Are there documents? What leads you to believe a crime was committed and this particular person committed it?
Yeah, we got another call. Want to flip over? Hello, welcome to Reasonable Doubt.
Hello, good show.
Thank you.
I missed the part where you discussed Goforth.
Yeah.
Where did the discovery come? Did it come from the defense or the state, or did the defense tell the state, hey, you got to release this to curry favor with the state?
No, the state the state released it, although I believe the defendant's lawyer had already had his investigator working and at least knew about the relationship with Goforth by this woman, but did not know about the latest revelation, which came from the DA's office themselves. I want to go back to what we were talking about before we jumped on the phone, and that was the law in California for prosecutors who intentionally withhold evidence. And I want to kind of link it together with something that just went on here in Harris County and is going on now, and that is the recent case involving the revelation of FBI payments to witnesses after the case had concluded. A defendant was convicted, and it was revealed after the trial that the FBI made payments after the verdict to witnesses, and there was no disclosure of these agreements. That case is obviously winding its way through the post-conviction stages, but I mean, a law like this would help give some teeth.
Assuming that the prosecutor knew about it, and I wasn't involved in that case, but if in fact what I read is true, that they approved the payments the next day,
yeah,
and the prosecutor was involved in that, absolutely that should fall under this category, and that's exactly what we're talking about. That's why we need the law, because that's not the way we prosecute people. We don't prosecute people in the dark. That's not the way our system is set up. There are systems throughout the world that's the way it is, but when the United States was formed, that was one of the very basic tenets of what we do, and that is we don't prosecute people in the dark. We give them the evidence, and they are supposed to give us the things that are viable for us.
Now, to be fair, the DA's office response is that they didn't know about the agreement, that the FBI didn't share with them, that this was the FBI's intention. And they're hiding behind, can't say that they're hiding, but they're taking the position that, look, the feds aren't communicating with the state. The glorious DOJ doesn't tell us what's going on. We're at their behest, and we're on a need-to-know basis.
That does not work. The government is the government is the government. Whether you're the state government or the federal government, we all know that the knowledge of one part of it is imputed to every other part. You don't get to just turn a blind eye to these things. You don't get to just put your head in the sand and say, I don't know what's going on out there, but I know I didn't make an agreement with them. That's not the way it works. They have an obligation, and the federal government knows they have an obligation.
Yeah.
Well, even the papers that the district attorney's office filed just recently responding to this allegation say, well, we didn't really know, and we don't control the FBI and who they pay and who they don't pay. At the very least, though, why wasn't the prosecutor saying up front, you know what, guys, I think the FBI might be thinking about a deal. I don't know if they're going to get the deal or not. I don't know if it's going to work through. That's up to them. But hey, you just need to know there's this potential out there.
Well, I can't imagine that the state prosecutor didn't at least have some conversation with the FBI about the case in general.
Well, they had to have for the whole thing to be connected. And as I understand it, the FBI is now saying, and through the prosecutor's office, they're saying, well, the FBI gave them this as a relocation expense,
right,
because we didn't have the money to relocate them. Okay, if we don't have the money and we pass that off, we need to be telling somebody, we just passed off this responsibility to the FBI, so you might want to follow up with them and see if they're paying your witnesses.
Well, yeah, I mean, and if somebody's getting a relocation fee, that's still conferring a benefit. You can't say that, well, because it's a relocation fee, somehow it's exempted from us handing it over to you. And you know, I was talking to somebody else the other day about it, and it's not really a Brady issue because it's not necessarily exculpatory. It's what we call a giglio issue. And it's, you're, by the Supreme Court, you're entitled to know any agreements that the government has with its witnesses.
But
whether they're exculpatory for you or not, just because it goes to the witness's credibility.
Well, exactly, and it goes to credibility. And so while you say it's not necessarily a exculpatory issue, it is a credibility issue, which could be exculpatory. Is this witness testifying that this defendant participated in exchange for some money to move out of town?
Well, and every expert that I've ever called, the first question out of the prosecutor's mouth, if I haven't already asked it, is, how much are you getting paid to be here today? I mean, it absolutely goes to credibility. I mean, that is one of the very first questions that's always asked when there's an expert involved. And so, you know, whether you call him an expert witness, whether you call him a civilian witness that's getting paid, we need to know that. Everybody wants to know that.
Yeah, and again, now we have the stench of possible withholding of some sort of information, and I mean, it keeps happening. It just keeps happening.
It happens every day. It happens every day.
Do you think we'd actually get a law like this in Texas?
I don't see it happening in Texas. The prosecutor's lobby is extremely strong. They have a great connection with law enforcement, who also has a great lobby in the legislature. I don't see us doing it anytime soon. Hopefully Senators Ellis and Whitmore and a few of the others will say, you know what, this needs to change. Because they've done some great things and passed some good legislation to level the playing field, and I hope they'll continue to do that. But I don't see this one coming anytime soon.
What about do you think that there needs to be more oversight from the federal government in this area? I mean, you know, there could be some sort of federal law that's enacted in the same vein. I mean, and not just at the federal level. I mean, obviously the federal rules of criminal procedure could be amended to give federal judges the power to do that. But it seems like they could set some sort of standard with this at least.
I think the problem is enforcement. And one of the problems that we as lawyers face is we deal with these courts every day. And when you start pointing the finger at somebody and you start accusing a DA's office of unethical behavior, the wrath comes back at you.
Yeah.
I mean, and not just from that DA, but from the entire office. You get put on the list. And, you know, it's a real problem because it is very difficult to stand up and say, wait a minute, this is a violation of Brady, or this is a violation of whatever it is. And you're pointing the finger, and you know somebody's career's on the line. That's why I think that you need the law. Because if the law is there is going to be some incentive for somebody to say, you know what, my job and my career is not worth not turning over this piece of paper. I'm going to give it to them. And I'll give all the prosecutors a little tip. If you don't think you should turn it over, turn it over.
Yeah, that's your first clue.
Give it to us.
That's your first clue that it ought to be turned over, that you have to even think about it.
And I'm still befuddled by why they don't just turn over every single thing that they have access to. It just makes no sense to me. Just give it to us.
Yeah.
Anyway.
Last item I want to get to tonight, this judge down in Florida sentencing a domestic violence victim to jail time for not showing up to testify in the case that she was the complaining witness in. This is outrageous to me. The fact that a judge, this woman showed up in tears. You know, she didn't want to confront her accuser. She didn't want, there's a whole backstory of it. I don't really have a whole lot of time to go into the relationship aspect of it, but we've all seen this before where a complaining witness doesn't want to show up, whether it's a domestic violence case, whether it's a robbery, whether it's a theft, whether it's an assault. Complaining witnesses decide they don't want to show up, okay? Why are you going to throw them in jail? Yeah. This is outrageous.
It makes no sense whatsoever. The judge has the authority to hold people in contempt for violating court orders, and the subpoena to appear is a court order. But you're talking about the complainant, who is an alleged victim, and you're going to victimize her even more by throwing her in jail if she really was a victim. You know, or perhaps, which we see here all the time, victims say, or complainants say, you know what, I don't really want to prosecute. That's not really the way it happened. Emotions were high, it was heated, and I said some things I shouldn't have, and you know, I need to set the record straight. And we still see the state wanting to prosecute those cases. The complainant doesn't get any help.
Yeah.
I think the real rub for me is, and it's a rub, it's the lack of understanding of citizens. The lack
compassion.
of compassion. It's like, look, you're a judge sitting up there high and mighty, judging this person who's at least alleged that she's been a victim. Whether she has been or not, there's not been a determination. But she's saying, look, I'm reaching out for help here by calling the police. Now it's part of the backstory that you're talking about. What a lot of people don't know, it's not like she just ignored it. She came in and said, look, I've got increased anxiety by coming in here. I'm scared. I don't want to confront this person because of the anxiety that I have. That's the reason I'm not coming to court. Not just because I want to disobey your order. I'm scared to death to be in this courtroom right now. And with that background, how can you as a judge not have some compassion for that individual?
Well, compassion for all kinds of personal situations. You know, things happen. People that come before the court, whether they're lawyers, witnesses, complainants, they're people first. They're humans, and a lot of our judges, I won't paint the brush that broad, but a lot of our judges have no compassion for those people that appear before them.
Yeah, we were talking
That's
about
the
this
problem.
on another issue here before we got on the air, and it's just the raw human aspect of this, set aside whether you're wearing a robe or whether you have a badge. I mean, when in this system can we start to treat people as people and not just as a number or not just like some animal that we, have moved from cage to cage?
And you say even like a person in a robe or a badge, go back to Sandra Bland.
Yeah.
Did she deserve to be treated that way on the side of the road? No, she didn't. We have people with robes, with badges, with whatever, that just want to exert their authority. We need to step back and be a little bit more human, a little bit more compassionate and sympathetic. Not every person needs to go to jail.
The thing is, and we've all heard it, that in domestic violence cases, and there was a high-profile one involving now Dallas Cowboys player Greg Hardy, where he was actually convicted, it was reversed on appeal, it went back for another trial, and the complainant in that case decided not to show up the second time to testify because they had reached a civil settlement. Stuff like this happens all the time, and we get the standard line from the state, well, the state can still prosecute this regardless of whether they have the witness or not. But
Can and should are two totally different things. Just because you can prosecute it doesn't mean you should.
I mean, again, compassion and judgment. Where does it start? I mean, who makes these policy decisions, I guess, to say, well, we're going to prosecute a case no matter whether the complainant wants it or not?
Think about it, Dane. You were a prosecutor. You mentioned that earlier. I was a prosecutor. You've got to use some discretion, some compassion. There might have been an assault that occurred, but now, you know what? The parties all say, we really don't want this to go through the criminal courts. Where's the respect for that decision on those parties?
Exactly.
It's missing in our judicial system, that is for sure. There is no respect for those decisions that are being made. And you know what? Something happens. Things happen in very heated moments that everybody wants to take back. It doesn't mean somebody needs to be labeled a criminal for the rest of their life because of that.
Well, and a lot of complainants make these decisions not to go forward for a variety of reasons, and I think people should start to respect those reasons. I mean, if somebody decides not to pursue a case, it should be just like in civil court, where they're allowed to dismiss and not pursue the case any further. But my opinion doesn't really matter all that much. I'm not in control.
Let me know when they start doing that, Jimmy.
Yeah, I know, exactly. But we're reaching the end of our time here, guys, and Dane, I want to thank you for coming on. It's been
Thank you so much.
a great time having you here. You've given some really great opinions, and JoAnne, thanks for showing up to do the co-hosting duties tonight. I know we originally were going to have you as a guest, and then you kind of slid over and took the co-host role. So
well, Julio had to be in trial. Somebody's got to step in. That's great. He's in trial, working hard.
I appreciate it. It's been a good time, guys. It's been a really good time, and I want to thank all our viewers, thank all of our phone callers, and all of our people commenting on Twitter. If you'd like more information on our show, I encourage you to go to our website, www.hcclatv.com. We have all our past episodes up there, including all of our 60-second law lessons. You can find a really great law lesson that we just gave on domestic violence and what to do if you find yourself in a domestic violence situation. And we'll have all our 60-second law lessons up there on our website, including our blog, which JoAnne is a frequent contributor to. So go there, get more information about the show. You can also like us on Facebook, get all of our clips and topics right there for the coming week. And we encourage you to go to our Twitter handle and follow us there. Send us your question and comments, and we'll take them live here on the air every week. We're set up for phone calls, and we appreciate you guys being here every week with us. And we wish you guys a good night, and we'll see you next week. Thanks a bunch. Good night.